Hello and welcome to my video podcast, Navigating Commercial Disputes. I am Payal Chawla and I'm delighted to bring you this series in collaboration with Bar and Bench. Through this podcast, I aim to demystify complex commercial legal issues for lawyers, law students, and legal enthusiasts alike. In today's podcast, I examine a fascinating question: how a dispute between two Indian parties, Antrix and Devas, found its way into the US courts, what the US Supreme Court said about the jurisdiction issue, and the future of enforcement of this arbitral award. The US Supreme Court recently clarified the scope of personal jurisdiction over foreign states under the Foreign Sovereign Immunities Act, or FSIA. The court held that jurisdiction exists when two conditions are met: proper service of process and an applicable exception to sovereign immunity, such as the arbitration exception. In rejecting the Ninth Circuit's minimum contact requirement, the court resolved a long-standing circuit split and reinforced Congress's intent for clear and predictable framework. The Antrix-Devas dispute illustrates the point. In 2005, Antrix, the commercial arm of ISRO, agreed to provide Devas multimedia S-band responders for telecom services. But in 2011, the Indian government reserved the spectrum for its own use, prompting Antrix to terminate the agreement. An ICC tribunal later held the termination wrongful and awarded Devas a whopping $562 million plus interest award. The enforcement proceedings then spread across multiple jurisdictions, including the United States, where Devas petitioned the Washington District Court to confirm the award. The district court confirmed the award, rejecting Antrix's jurisdictional challenge. On appeal, however, the Ninth Circuit, bound by precedent, held that minimum contact were required under FSIA and found them lacking, a major victory for Antrix. Meanwhile, in India, the Delhi High Court set aside the award on grounds of illegality, fraud, and conflict with public policy. Subsequently, Devas also went into liquidation. On June 5, 2025, the US Supreme Court unanimously reversed the Ninth Circuit's ruling, holding that FSAI requires only a statutory exception and proper service, not minimum contacts. The case is now remanded back for enforcement proceedings. But the key unresolved issue is whether the US courts will enforce the arbitral award that has already been annulled in India. Ordinarily, they would, unless the annulment proceeding itself was seriously flawed. It is my privilege today to host one of the leading figures in international arbitration, Mr. Mark McNeill. Mark is a barrister at Briggs Court Chambers and was previously a partner at a leading New York law firm. With over 25 years of experience as both advocate and arbitrator, he has acted in high-stake commercial and investment treaty disputes across various jurisdictions and industries, ranging from energy and technology to pharmaceuticals and mining. He is admitted to practice in New York, Paris, and England and Wales, and is known as a formidable cross-examiner, one you would not want to face in the witness box. Welcome, Mark. I'm so delighted to have you on the show.
Thank you for having me, Payal, and thank you to Bar and Bench.
Mark, tell me, this is a dispute between two Indian parties. How did it end up in the US courts?
Well, it's a very interesting story. The dispute arises out of an original satellite agreement, which dates back to 2005, which is over 20 years ago, believe it or not. And the ICC decision, which resolved that dispute at the level of the arbitral tribunal, was rendered in September 2015. So almost exactly 10 years to the date of this podcast. Devas took the award and sought to enforce it in jurisdictions around the world, in the UK and France, and they went to the US as well. Antrix had certain business contacts with Washington State, and so they went into Washington State Court to seek to have the award, the arbitral award, the ICC award confirmed, right, which is necessary to convert it into a judgment, which then can be enforced all around the United States against assets that meet certain criteria.
Right.
So that's how it ended up there.
And this was the District Court of Washington?
It was the District Court, the Western District Court of Washington State, yes.
And so they confirm the award, that's the first step before enforcement.
Yes, so confirmation or recognition is the first step, where the court basically issues an order. It's done by way of motion, technically. The court issues an order which appends the arbitral award, and that becomes the judgment. So the court there issued a judgment in the amount of $1.29 billion. I think the original ICC award was $562 million,
right,
but it had very high interest, pre-award, post-award interest. So by the time it got before the district court in the US, judgment was entered for $1.29 billion.
And so then Antrix appealed this decision, or did they do a motion to dismiss? What happened?
Yes, so Antrix raised before the district court first that it challenged personal jurisdiction, right, before the district court first. And it said that you don't have jurisdiction over us because there are not minimum contacts with the forum, with the US.
I see.
So, and that's a requirement under Article 5 of the US Constitution and under the Foreign Sovereign Immunities Act, and you don't have personal jurisdiction. The district court rejected that and said there is no minimum contacts due process requirement under the Foreign Sovereign Immunities Act, including under the arbitration exception, which is what the claim was brought under, and dismissed those arguments and then entered judgment. And then Antrix appealed that to the Ninth Circuit.
And so what happened in the Ninth Circuit? Because that came in favor of Antrix.
Yes.
Right?
Yes. The Ninth Circuit was the most interesting part of this saga. The Ninth Circuit took a very different approach and overturned the district court's decision and held that the minimum contacts test under the Foreign Sovereign Immunities Act, that there's a minimum contacts test that applies to this arbitration exception. It relied on a precedent going back 40 years, a case called Gonzalez by the Ninth Circuit, which had been brought under a different exception to the Foreign Sovereign Immunities Act, which was the commercial activities exception. That court had looked at that exception, which says the commercial activity must either take place in the United States or it must have a direct effect in the United States. And the court there said this looks a lot like the minimum contacts standard under the Constitution, and therefore will apply the minimum contacts test, right? So the Ninth Circuit in the Devas appeal said, well, we're going to apply the same test, albeit under a different standard, under the arbitration exception, and say that the minimum contacts standard must apply in addition to what's written in the Foreign Sovereign Immunities Act, Section 1330B, and say that there's a minimum contacts requirement. And then in addition to that, it applied that test, and then it said that there were not minimum contacts. So it disagreed on the substance as well with the district court, which had found that there, even if there were a test, that there were sufficient contacts, the Court of Appeal said there were not sufficient contracts because the contract had been negotiated outside of the US, it had been executed in India, and the contacts were basically random and fortuitous, right? So they weren't deliberate contacts. The magic language is that you must purposely avail yourself of the benefits and protections of the forum, and Antrix had not done that, and so there was no personal jurisdiction over Antrix. That's what the
Ninth Circuit
the Ninth Circuit.
So just for the for clarity for our Indian audience, explain what is the personal jurisdiction test, because otherwise this would have gone to state court, right? Because there are two Indian parties.
Yes.
You need to meet this personal jurisdiction test to bring it under federal court. Is that right?
Yes. It's personal jurisdiction in U.S. law is very complicated, sometimes unnecessarily complicated, especially for non-U.S. lawyers. Before 1945, it was actually a very simple territorial but inflexible test, very rigid test, which says, is the defendant physically located in the United States or in the forum, if it's between two U.S. parties, let's say, in the particular state, or if it's an action in rem, is the property located in the U.S. So it was territorial and it was physical. There was a case called International Shoe, a very famous case that all U.S. law students become familiar with right away, which applied a very different test and said that we will look at the contacts that you have with the forum. So it applied a very flexible test basically international commerce had expanded greatly in the years, and there was more cross-border corporate activities, and there needed to be a different test. And so it looked at basically a tripartite test. One test is, how connected is the claim to the contacts, right? Does the claim arise out of, or is it connected to the contact? What is the nature of the contacts, right? And it looks mostly at really the substantive, instead of the number of contacts, the substance and nature of the contact.
Right.
And then it applies on top of that basically a fairness test, a balancing test. What is the burden on the claimant? What is the burden on the respondent? What is the interest of the forum, of the state, in maintaining jurisdiction? And so it moved from a very rigid territorial test to a much more flexible test. I mentioned before purposely avail. That was a test that came in subsequently in a case called Worldwide Volkswagen. Basically said, you can't just have fortuitous or random contacts, you must have purposely availed yourself of the benefits and the protection of the forum in order for it to be consistent with the due process requirements under the Fifth Amendment, under the 14th Amendment for state actions, or under the Fifth Amendment for international actions.
ISRO is the party which is the party that holds Antrix, and that's a state. It's an Indian state body that owns Antrix. So normally it would be entitled to sovereign immunity, with the exception, the only exception being arbitration.
Yes, that's right.
So
the Foreign Sovereign Immunities Act has four main exceptions in Article 1605. One is commercial activities,
right.
And that's what the Gonzales court
ruling was
looked
about.
At. The arbitration exception, which basically says if there's an action to enforce an arbitration award, that is an exception, and it confers subject matter jurisdiction if it meets any of these tests. Expropriation, and then terrorism, right? So those are the four main exceptions. The exceptions in Article 1605 effectively confer subject matter jurisdiction. A separate section of the FSIA, the Foreign Sovereign Immunities Act, 1330B, confers personal jurisdiction, but it requires that subsection A be satisfied, which refers to the exceptions. So they're all tied back ultimately to the exceptions, but the exceptions confer subject matter jurisdiction, which then ties back to personal jurisdiction. I think the Ninth Circuit seemed to have conflated those two things.
I see.
Because it sought to read into the exceptions in 1605 this minimum contacts test.
Which is in addition to the exception of arbitration, am I getting that right?
It's in addition, exactly, and you put your finger on exactly what the issue was. So 1330B just says there are two requirements, right? That it must satisfy one of the exceptions, and you must have proper service on the defendant.
Correct.
And once those are met, that's it. If you look in 1330B, it doesn't mention anything about minimum contacts. And certainly if you look in the exceptions in 1605, it doesn't mention anything about minimum contacts. You wouldn't expect it to find it there because it's not a personal jurisdiction, it's subject matter jurisdiction. But you don't find it anywhere. So that was the unusual finding by the Circuit Court.
And this decision was criticized by the sitting judges of the Ninth Circuit in the en banc hearing, is that right?
There was an application for an en banc hearing which was denied. One of the dissents in particular was a very powerful dissent. It was very persuasive and was relied on very much when it ultimately went up to the Supreme Court. You can see a lot of the similar language. But basically the dissent said that this not only borrows from Gonzales, but it expands it because it's using a different exception, the arbitration exception. There's no language in the FSIA which suggests that the minimum contacts test should apply. And so we're basically legislating, we're not acting as a court.
Right.
You know, the Congress and the Gonzales Court and then the Ninth Circuit in Devas also looked at legislative history. So that there was a House Judicial Committee report which mentioned personal jurisdiction, but it didn't really say that a minimum contacts test must sit on top of the FSIA, which is what the Ninth Circuit ruled.
And just for my understanding, Gonzales was from the Ninth Circuit?
Yes, exactly.
And the court felt that since the Supreme Court hadn't overruled it, it was bound by the decision of Gonzales because other jurisdictions have held otherwise.
That's right. So the Second Circuit, 7th, 11th, I think the DC Circuit have all unanimously held that there is no minimum contacts test that sits on top of the Foreign Sovereign Immunities Act. So California has been an outlier now for a long time, starting with Gonzales over almost 45 years ago now. It has been an outlier around the United States. So there's been a split between the circuits, but California, or the Ninth Circuit, I should say, is the only circuit which has found this.
Right. So then the matter traveled to the Supreme Court, the US Supreme Court,
Yes.
and what did they do?
So the Supreme Court, it was a very short, terse, powerful decision written by Justice Alito. It was a unanimous decision, 9-0, and there was just no uncertainty by the court that there is no minimum contacts test.
Right.
The Supreme Court even called the Ninth Circuit's statutory interpretation strange, and it said it's reading words into the statute that don't exist. It's relying on statutory, background materials, the committee report, and it's misreading it's reading words into the statute that don't live there. So the minimum standards test, the minimum contacts test under an international SHU is a domestic standard. The FSIA is the comprehensive basis for jurisdiction, assuming jurisdiction over a sovereign. What's in there is in there, what's not in there is not in there, and that's it. You apply the words as they're written.
So, and this is a major win for Devas now. But so what happens? The court is remanding the matter back to the Ninth Circuit for enforcement?
It's being remanded to the lower courts.
To the district court?
It's a little complicated because there are several issues that the Ninth Circuit and the U.S. Supreme Court did not decide. So it did not decide the separate question. So the question was, does a minimum contacts test apply under the FSIA? There's the separate question, and you can see the Supreme Court deliberately left it open. It said, is there a separate independent test under the Fifth Amendment of the Constitution, which still applies minimum contacts?
Right.
I think if you read the district court decision, you would conclude that that's unlikely to succeed, I would guess. But that technically was left open. Also left open is the question whether the dispute falls within the arbitration exception to the FSIA. Right, so that still is to be decided. And then also there's a forum nonconvenience argument, basically that says the the U.S. District Court for the Western District of Washington is not the appropriate forum. There's a more appropriate forum, either in the U.S. or abroad, and so it doesn't belong before this court. So those decisions have been remanded and have yet to be decided.
So the enforcement question itself is not before the district court anymore, or will that be there as well? Because that's really where the Indians are interested.
Well, it's interesting because it's so many years on. That's why I mentioned at the outset that we're now 10 years after the original award, because there's still a long road to go in the U.S. You still have to get through these jurisdictional and venue questions,
right,
before you get to enforcement.
I see.
And there's, when you get to enforcement, that's a very big deal there as well. It's interesting because what was not disputed before the district court was whether Antrix is basically the equivalent of the sovereign, right? And it's a much lower test under the Foreign Sovereign Immunities Act for purposes of personal jurisdiction. Basically, they say, is it at least majority owned by the state?
Right.
And it doesn't look into these more nuanced questions about control. When you get to enforcement, they will have to revisit that question.
Oh, very interesting.
And it's a much higher test. So I represented Karen before the Southern District of New York in enforcing an award and seeking to enforce an arbitral award against Air India. And so the same questions will arise there. What is the relationship between the state and the separate legal entity, Air India, or in this case Antrix? How much control is there? Ownership, of course, commingling of funds, and it looks at all of those. And basically, you have to prove that it is an instrumentality of the state or an alter ego of the state,
right?
Which is a very, very high standard.
I see.
So it's so even if you get through, if you do these jurisdictional and venue questions, and you get to enforcement, that Devas still has its work cut out for it, proving that that the assets are sovereign assets used for a commercial purpose.
I see.
That's the limited category of assets it can go after.
So assuming we get to that point and they clear all the jurisdictional venue questions, in your opinion, can this award be enforced because it has been set aside in India, the ICC award?
That's right, set aside by the Delhi High Court.
Yeah. And also because the Supreme Court in a way dismissed the SLP, so it's attained finality in
exactly.
India.
So yeah, exactly. So it's in India, and in the Indian court system, it's final, that it's annulled. The U.S. is, I think, categorized as a more pro-enforcement jurisdiction. In particular, there's a very strong federal policy under the Federal Arbitration Act, the FAA, in favor of arbitration. And there have been instances where a decision that has been annulled at the seat in another country, another New York Convention country, has still been enforced in the United States.
Okay.
The starting point is really the New York Convention, in Article 5,
Right.
1E, which says that an arbitral award may be enforced even if it's been set aside, right, under the laws of the state or in the country in which it was made, right? And so it's permissive, right? Most U.S. courts have respected, though, annulment decisions. That's sort of the default rule, and I think that's supposed to be the default rule around the world. I think it is in just about every jurisdiction. So most cases that get before the U.S. District Court, if it's been annulled somewhere else, that will be respected. The first case in which it was not was the 1996 case called Kromoloy. It was a decision against Egypt. The Egyptian court set aside the award, and it was still enforced by the D.C. District Court. And it looked at basically the fact that the Egyptian court had done a substantive review of the arbitral award, not a review, it didn't criticize the procedures,
Right.
It looked at the substance. And also the parties had waived their right to seek annulment, to challenge the award. And that was ignored by the court, and they went ahead and annulled the award. So the U.S. court said, this is too much for us. We are going to enforce this award anyway. The next case was Pemex, and it was a Mexican court that set aside the award. That was a couple years later. And that was the Fifth Circuit in Texas. And it was a similar issue. They looked at, I guess, two main things. One, it was a substantive challenge to the award, a substantive review of the award by the court, which they're not supposed to do. And there were some due process concerns, right? Had the parties really had the full opportunity to argue this annulment proceeding? And what standards had they applied? And do they violate U.S. public policy? And then there was the UCOS decision more recently. It was set aside on sovereign immunity grounds, but before the court did so, it indicated that it might be willing to enforce the award because it looked at the Russian courts and it said, are they independent? Was there due process? Was this a lawful activity? So if you take that framework and you think about the Devas situation, how would a U.S. court handle that? I think you can make arguments going different ways because it was set aside basically on fraud grounds. And fraud is, in principle, a legitimate and recognized basis for annulling an award, for not recognizing and annulling an award. So you have that. And multiple tribunals reached that conclusion. So the National Companies Law Tribunal, NCLT, and then the Delhi High Courts. You have multiple tribunals.
Right.
And also, the Devas is now before the courts in Washington, which is part of the Ninth Circuit. The Ninth Circuit, there's a bit of a split in the approach among the different circuits in the U.S. The Ninth Circuit and the Tenth Circuit are better known for respecting an annulment at the seat, and so maybe they're not in the most favorable jurisdiction. On the other side of the equation, you can imagine that Devas will say that before the tribunal and before the court, there wasn't a full evidentiary hearing on the fraud issue.
Right.
We didn't have a chance to plead our case. There was political influence, they may argue. I mean, they'll bring out all of the arguments that they take from Kromoloy, Pemex, UCOS, and harvest those and try to make a similar argument.
Right. In addition to the ICC award, there are also BIT-related arbitrations pending, and
Yes.
some decided?
Yes, and the Devas dispute, I think, is truly befitting the term saga, right? Because it has so many different parts to it. It's, as I said, it's been going on for over 10 years. The ICC case is the one that's ended up before the U.S. courts. Two parallel BIT claims, one under the German India BIT and one under the Mauritian India bilateral investment treaty. There have been enforcement actions in Australia, France, the UK, the US, Germany, and elsewhere. Devas itself has been put in liquidation, and then the award, the ICC award, has been set aside. And then you have decisions by the Mauritian Supreme Court as well. So you have all of this enormous confluence of all these different decisions and actions which are going on. It's really fascinating to behold, and no one really knows what's going to happen at the end of the day. The BIT claims they're interesting, and they're a little different from the ICC claim because they have the Devas, or as the shareholders and the liquidator, are having more trouble enforcing that in certain jurisdictions. So an Australian federal court has ruled that because India has taken the commercial exception under the New York Convention, and under Indian law, this decision under a bilateral investment treaty implicates public international law, and the decision which undermined the satellite agreement to begin with was a matter of public policy, right? That this S-band was being reserved for government military purposes, and this was a public policy decision. So this is not a commercial dispute at all. Interestingly, Australian federal court has accepted that argument. So that places one more roadblock in the path of the enforcement of these BIT
ICC
cases.
No, in the BIT.
In the BIT case, because the BIT case is, arguably it's a case that implicates public international law and private international law. And, at least according to India, it is not a commercial dispute when it's a dispute under a bilateral investment treaty.
And how would they reconcile the ICC award with that?
Because there's no superstructure that governs how all of these things interact,
Right.
You see sometimes, especially in the bilateral investment treaty, space, you see multiple claims. India has been subject to multiple claims with respect to certain disputes in particular. And there's no way to really coordinate those. I think at the end of the day, you're not going to be able to double claim for the same amount.
Right.
And I think that's well established. It's a little unfortunate I spent a lot of time defending the United States in investment treaty cases, and I have a lot of sympathy for the idea that the same claimant or the shareholders, in the same claimant can bring multiple actions in multiple fora, before Mauritius, the German BIT, the ICC, and attack you from multiple angles. So, but if you're Devas, on the other hand, you want to deploy every single, avenue at your disposal and see what works. Because you can see how complicated, even just in the US and the jurisdictional issues,
Right.
how complicated it is. And you're not certain which avenue is going to succeed in the end, both in terms of getting the award to begin with, getting it confirmed, and then enforcing against assets. And every jurisdiction in which they're in has significantly different law in terms of sovereign immunity over the assets, piercing the corporate veil, which is a little bit easier in the US than in some jurisdictions, but it's all quite different. So you don't know how it's going to play out. So that seems to be the game plan, is to go through as many avenues as you can.
Before we end, do you want to second a guess what might happen?
It's hard to say. I would like to think that there might be some, there's a lot of pressure because the amount, by the time it got to the district court, it's up to 1.29 billion. I don't know what it's up to today, but the interest rate, I think the post-judgment interest rate was 18%. So it's growing rapidly every day. As we sit here, it's grown another few $100,000. So I think there's a lot of pressure to put this dispute, behind the parties. It's been a long time. So maybe I'm an optimist, but I would think that there might be some sort of settlement at some point.
At some point, yeah.
In my dispute with Karen, there was ultimately a settlement which resolved the issue, but it's hard to say. When it's hard for states to settle these cases. I know that very well, having worked for the U.S. government. It was something which was politically always very difficult to consider. And that's something which is almost impossible to guess, really. It's just a matter of how the pieces all fit together. In terms of the legal proceedings, will Devas ever succeed in collecting? I think probably they will. I think that they will make it through the venue and jurisdictional issues in the U.S. court.
Okay.
I just don't know what the nature of the assets are that they can look at in the U.S.
I think they managed to find a claim in Virginia.
That's exactly right. Antrix is a creditor in bankruptcy proceedings in the Eastern District of Virginia. And it's interesting because the shareholders and the subsidiary of Devas intervened in the district court action. They got post-judgment discovery. They uncovered this claim in the bankruptcy through that process. And then they're seeking to get access to it. And meanwhile, opposing their actions is Devas itself, believe it or not, and Antrix, both opposing their intervention and their attempt to get at this asset. So that's one asset we know about, is that there is this claim in the bankruptcy. There's probably more, but it's hard to guess the outcome without knowing more about. Devas has certainly hired investigators and has been looking into this for many, many years, what types of assets that they might go after.
Thank you very much, Mark. This has been very insightful.
Thank you, Payal. It's very enjoyable.
This concludes today's episode of Navigating Commercial Disputes. Stay tuned for more insightful conversations on legal issues that matter most. For a more in-depth analysis, read my article dated 27 June 2025 by following the link below.